Welcome back to The Cold Truth, in which we have exposed the laws of the United States that make abortion clearly illegal. Next, we will talk about Roe v. Wade, the case 89% of pro-choicers surveyed believe means they have the right to commit abortion when no such statement was ever made. First, before getting too far along into the actual nitty-gritty of the law, we must explain what power the Supreme Court does and does not have, according to the Constitution's third article. The common misunderstanding of citizens of the United States is that the Supreme Court and the lesser courts that serve under it have any power to make laws whatsoever. This misunderstanding is made abundantly clear by the sheer volume of women in the post-Roe v. Wade riot who believed Roe v. Wade gave them rights and that those rights were taken away. While judicial precedents are often referred to as laws, they are nothing of the sort. What they do represent is guidelines for future court decisions. These decisions are based on the laws that have already been written. They do not define what a law says, they only define what the law means. The Supreme Court's precedents affect all states in the United States, but any case that does not fall under the umbrella of Supreme Court decisions is left up to state Supreme Courts, and so forth. As a clear and not very controversial example, the 1983 landmark case Bethel School District No. 43 versus Frazier brought a youth before the Supreme Court who had made a speech to his school nominating a friend for class president. His speech was not overtly offensive, but was riddled with sexual innuendo. The speaker was suspended and, subsequently, withheld of the utterly criminal and morally bankrupt American Civil Liberties Union, sued the school for violating his right to free speech. The Supreme Court eventually got involved and determined that the student's freedom of speech did not mean the school did not have the right to punish him for what he said. This did not establish a new law. It used the laws that were already in place to define a new precedent. That precedent means that whenever a student uses their freedom of speech in an offensive way, the correct interpretation of the law is clear. The school has all right to suspend the student. The Supreme Court does not need to get involved again. However, no new law was made. The law that already existed defined the right of the school to crack down on lewd speech. The Supreme Court just made that point clear. This is a fairly benign example that most Americans are in favor of. The landmark case of Roe v. Wade is very different, however. First, it must be made abundantly clear that before Roe v. Wade, abortion was nothing new, and laws had existed to forbid it in some places and permit it in others. Specific, readable laws had already existed defining and honing abortion since 1821, 152 years before that case. That does not mean that those abortions were not murder, just that Roe v. Wade was not the defining moment of abortion law. The description of the case, as it is typically presented by liberal schools and media, is that a woman wanted to have an abortion and was not allowed to. They say the Supreme Court made a law allowing her to get an abortion. This is the narrative we have heard 1,000 times. It could not be more wrong. The truth is much more sinister, yet eye-rollingly silly. In 1970, a very liberal female lawyer from very conservative Texas by the name of Sarah Weddington came forth. Some would depict her as an American hero, but her actions were truly as contemptible as they were dishonorable. She reached out to the community and asked someone to come forward who was both pregnant and did not want to be. Typically, solicitation of clients without an existing connection is legally forbidden for lawyers. Weddington, who would later serve as a member of the Texas House of Representatives, justified her actions as being for the public good. Typically, Weddington should have been disciplined, but she used her legal knowledge to slither through loopholes in the law. This solicitation occurred because Weddington had the idea and could not get it out of her head that abortion should be a protected right in the state of Texas. Despite the grand majority of her clients, cohorts, and local judges disagreeing with her, she took on this pet project which seemed, at least in historical retrospect, significantly more about cementing her own career than it ever was about saving lives. Her first pick for a client was a woman with a serious disorder that would never allow her to carry a child to term. This is the type of circumstance under which abortion had typically been legalized in most places, even back then. Her firm did not want to take on the case because the woman was not pregnant, and her only defense was that she and her husband liked unprotected sex a lot. The firm determined that they could not take such a huge gamble on any Texas judge saying she could have an abortion whenever she wanted, even with her condition, on the grounds that she could have done something to prevent pregnancy in the first place. So Weddington continued to ask women if they wanted to be part of her case. Again, this kind of solicitation was and still is illegal in at least 47 states, including Texas, with some kinds of solicitation subject to significant discipline. That law does not prevent the kinds of solicitation you see on the freeway when a lawyer puts up a billboard saying, "I can help you get justice." That refers specifically to saying, "I have a court case developed here, and all I need is someone to become the face for it." The latter is what Weddington did, a tactic that 85% of lawyers surveyed find somewhere from unethical to immoral. As her exact tactics have never come to light, it is hard to know just how illegal her solicitation was or how severe the discipline should have been. Since no case had been established yet, Weddington and her assistant Linda Coffey took their time trying to narrow down exactly how they would win in one fell swoop. They identified that their suit would perform best in Dallas, which was known to be more liberal. They wanted to meet with a tribunal, not a single judge. They wanted to be sure that one of the judges was pro-abortion and had the clout and personality needed to persuade the others. While shopping around for a specific jurisdictional area was not technically illegal, many states have chosen after these events to make it so, and 72% of lawyers and 93% of judges surveyed are at least moderately against it. It is certainly frowned upon in a historical context. Despite being rejected by most organizations they appealed to, Weddington and Coffey were eventually hosted several times to give speeches to coerce women who were looking for an easy out from pregnancy to come to their side. It took some time, but eventually they solicited Norma McCorvey, a married 21-year-old who wanted an abortion for her third pregnancy. The lawyers agreed that McCorvey would be the perfect patsy because she was young, pretty, poor, and white. The facts that she smoked an unspecified illegal drug and was an alcoholic were not taken into account. Weddington used illegal coercion to convince McCorvey that abortion should be legal because the baby was just a piece of tissue anyway, so it was not important and not alive. McCorvey, who would spend the rest of her life fighting against abortion and blaming Weddington for ruining her reputation, would say they pulled no punches trying to persuade her that she wanted an abortion. However, no abortion took place and the child was put up for adoption. Still, Weddington had found her golden goose, a girl whose status was so pitiable yet average that it would pull some judges' heartstrings and get them to make a new precedent, a precedent from which McCorvey would not benefit, but would bolster Weddington's own career for the rest of her life. She decided to use as the crux of her case the fact that McCorvey was denied an abortion, even though there has never been any evidence that she ever tried to have an abortion. Weddington applied for 2 different civil suits. Using the pseudonym Jane Roe to obscure McCorvey's identity and legal responsibility, she went against typical precedent and declared her suit directly against Henry Wade, the Texas state attorney, rather than against the state itself. Thus, the name of the case became Roe v. Wade, which makes it appear like a personal suit between 2 people, rather than a suit between a fictional person and the entire state. Though the name of the case should technically have been McCorvey v. Texas, Weddington spared no shame to subconsciously and sublegally tilt the scale in her favor. She also put out at least one other, if not 2 other suits with similar names, though they ended up consolidated anyway. The team managed to procure exactly what they wanted, 3 judges who were, for one reason or another, more sympathetic to their cause. Weddington also procured the help of a Texas doctor who was on trial for murder in 2 illegal abortion cases. The judges, to spare their career, refused to weigh in on this case for the sake of abortion itself. Therefore, the exact nature of the case as expressed by the judges was not to define whether abortion should be legal or not, but to determine which court level should have jurisdiction over abortion law. According to McCorvey, Weddington's preparations ignored the stated purpose of the court case and continued to push for a state constitutional amendment to allow for abortion, lock, stock, and barrel. Meanwhile, McCorvey, aka Roe, was not permitted by her so-called lawyer to be present for the proceedings at all after the opening arguments. At first, all 3 judges agreed in favor of Roe. This was largely influenced by the incredibly poor display from the state defenders, whose opening arguments were a farcical combination of sexist jokes and general derision. In the end, they determined that the state constitution, not the national constitution, had an ambiguous passage that did not define one way or another whether a Texas citizen should have to reveal the reasons for an abortion to the government. That is all. Nothing more, nothing less. An ambiguity in the law must be rectified, this is certain. They did not want to create a precedent that gave people a legal right to perform an abortion. Again, the judiciary cannot do that. All they can do is interpret the law. They interpreted that the 9th Amendment to the Constitution, which, as we read before, protects the rights not mentioned in the Constitution, meant that a woman has the right not to have to tell anyone why she wanted an abortion. This went off of another precedent that a married couple does not have to share their reasons for their actions. However, it was not long before the tribunal came into question by 4 other higher judges who determined that they would reject the ruling. Not even a year after Roe v. Wade was decided in Texas, it was brought up again for re-argument. Since no crime nor abortion had been committed, there was no double jeopardy clause in place. McCorvey was frustrated at having to continue to be a part of this farce, but Weddington may have been pleased. More discussion meant greater likelihood that the case would reach the nation and her career would be cemented in stone as a protector of women's rights. Ultimately, the judge who put forward the case to the Supreme Court was one of the 3 in favor of abortion rights. He was fueled, in his own words, by the belief that the possibility of community opposition is slight, and if such a theoretical case was carried to a high court, perhaps even the U.S. Supreme Court, and the judges confirmed a broad interpretation of the meaning of a threat to life, undoubtedly a landmark in abortion decisions would be reached. Those who fought against them made a blunder in this case too, by sending forth an attorney who already had a poor reputation as an exaggerator. The research performed covered extremely broad topics and presented abortion as a right according to the 9th Amendment. It took nearly a year to prepare the case. The facts were hand-chosen to present abortion as a right protected by that amendment. Once presented, the Supreme Court agreed 7-2 that the decision made in Texas was moot because Roe had already given birth 3 years before the Supreme Court ever even saw the case. They agreed that the First Amendment gave her permission to say or not say what she wanted. The Fifth gave her permission to not have to testify against herself, and the Ninth gave her legal protection that was not specifically mentioned in the Constitution. This, of course, is the main point that has come under fire. Is abortion a right? The Supreme Court may have fundamentally said yes, but only under the context that it isn't not a right. Many liberal reporting groups immediately published their version of the results of the trial all across the U.S. even before the decision was officially made. The book was never thrown at the reporters, but the report was ultimately fallacious. Remember, the Supreme Court interprets the law, it does not make it. No law was established that allowed or prevented abortion. All this precedent, not law, was ever supposed to do was to prevent courts across the U.S. from casting judgment on individuals after getting a legal abortion, whether a reason was filed officially or not. For 50 years, this court decision was abused and misinterpreted because people wanted to misinterpret it as a license to kill. In what would become known as, according to one scholar, undoubtedly the best known case the United States Supreme Court has ever decided, lines would be drawn. The sides would form between pro-choice, led by Weddington and her kind, who sought to grow their fame, along with support from the equally corrupt population control movement, and the sub-criminal ACLU, who fought against pro-life, led by the Catholic Church and other religious organizations that condemned the decision on the point of morality. All the while, the Supreme Court's reputation would be damaged by the thought that they would bring morality into their decisions in any way, shape, or form. The cold truth is, despite their decision, none of the Supreme Court judges ever stated that abortion is a right, only that the government does not need to know about it. No morality was ever brought into legal or lawful question, though morality was certainly a part of the initial discussion. In the end, the Supreme Court did what they felt was right based on the legal Constitution of the United States and the rights of the First, Fifth, and Ninth Amendments. 49 years later, in 2022, the Supreme Court of the United States brought the Roe v. Wade decision under review again. This is not, as is assumed by some, because of the former presidency of Donald Trump. Whether you like or dislike his politics or his character, Trump had nothing to do with this decision, and voting for or against him because of that decision is evidence of an individual's lack of political understanding. While Trump did, as have many presidents as per their constitutionally given power, recommended judges, that is the full extent of his judicial power as the nation's executive. Again, whether you agree with him or not, Trump was not responsible for bringing Roe v. Wade into question, nor the subsequent decision of the court during the tenure of Trump's political rival, Joe Biden. They carefully reviewed all the data from the past 50 years and before, as well as the full transcription of Roe v. Wade. They brought in many cases from state Supreme Courts that have used Roe v. Wade as a precedent to allow saline abortions, abortions after 12 weeks, and abortions in minors without parental consent. They challenged laws that were unconstitutional by the nation's constitution, but that some, not all but some, fit into the terminology of the state's individual constitutions. Likewise, the legal protection of abortion violated the constitutions of numerous states, which would require significant effort to rework, as the national laws supersede the state laws in the case where national laws and state laws contradict. Meanwhile, as we mentioned, neither Roe v. Wade nor the dozens of subsequent cases ever did or could establish a law legalizing abortion simply because that is not the Supreme Court's role. To end this mess, the Supreme Court determined 5-4 to kick Roe v. Wade down, as is their right as the federal judges, to the state level. Immediately, 14 states that reject abortion except in the most stringent of cases, and 3 states that rejected in all cases, made their own state decisions regarding abortion. In those 17 states, an average total of fewer than 150 legal and therefore countable abortions are committed annually between the states. With their population compared to that of the rest of the United States, this means about 1,000 abortions should be considered lawful in the United States every year. We will mention this more as time goes on, but that is about 1 in 1,000 abortions that are for valid, acceptable reasons, and 999 out of 1,000 that are not. This strongly disfavors former statistics that claim that half of abortions are necessary, as the total should have been closer to 140,000 based on the numbers we gave before. Required in those 14 states is that each woman seeking an abortion meet with a doctor a certain number of times and a psychiatric professional a certain number of times and get their seal of approval that the abortion is absolutely necessary, and that no abortion may be performed after 12 weeks or without parental consent in the case of a minor. As for the 3 states with full abortion bans, we strongly encourage them to reconsider and allow the border case circumstances we mentioned before. Though not every state is exactly the same, the numbers are still telling. It should be noted that while Texas, often considered the most conservative state, is one of the 14, Utah, which is often considered the most religious state, is not part of the 3 or the 14. So pro-choicers, do not blame religion for your lack of rights that were never yours to begin with. Clearly, it should be seen that abortion is not a right, and its use in the U.S. is based on the biggest farce ever to darken the Supreme Court's doorstep. Roe v. Wade cannot protect murderers. It is not a law, and it is now a state-level decision. If women and men too think it is their right to kill the innocent, they can do as our ancestors did and protest. Protest until your faces turn blue for all we care. The cold truth is unchanging and unfeeling. In conclusion of this point, we of Veritas Rigora will make it very clear, so that our speech is not taken as a soapbox for the Republican Party, that we are not affiliated in name or legal status with either dominant party of the United States. As much as we openly deride the Democrat politicians as criminals and murderers looking to establish socialism despite its proven failure, we also believe that the Republican politicians have, for the most part, failed to stand up for what is right. Republican politicians typically either gingerly toe the line of truth and make compromises with the devil, or else spend every effort to counter every point made by the left, even when they actually make a rare good point. We are not in favor of the modern Republican Party as a whole, but we are adamant protesters against the menace that lurks at the root of the modern Democratic Party. No matter how many small positive things the Democratic Party has done, we cannot forget that it at least claims to have persuaded half a nation to believe that abortion is not murder. Oh, that this was the party's only crime, but alas, their evils are legion. For today, we are only focused on abortion, but rest assured, we will not rest until the cold truth has been delivered about all of the demonic practices that the Democratic Party claims to stand for. While we are not in favor of Donald Trump's personal choices, and we do not necessarily agree with his laws, we appreciate his commitment and ability to actually do what he said he would, something most politicians cannot claim on their best days. We need more businessmen, scientists, and philosophers as leaders, not pawns of the predominantly liberal mainstream media who can speak sweet, alluring words but fail our nation time and time again, and not wishy-washy weaklings who use "it's the right thing to do" as their primary reason for their policies and then are unable to answer when asked to prove their point. Only the cold truth and those willing to share it can save this nation. As we will share next time, the cold truth is that most pro-choice women blame men for unwanted pregnancies, and this is an egregious lie. The cold truth is that abortion is murder, and we have the courage to say so.